Okay, start again. Mr. Tamborello is a practitioner in Houston in the areas of probate, guardianship, trust, estate administration, and general estate planning. He handles both litigation and mediation matters. Mr. Tamborello is a magna cum laude graduate of the University of Houston Law Center after he received his bachelor's degree from the University of St. Thomas. Mr. Tamborello has received numerous honors, including being named in 2016 as Super Lawyer Texas in Estate Planning and Probate, Texas Top Rated Lawyers in 2012, H Texas Magazine's Top Lawyers in Houston from 2007 to 2011, and finally, H Texas Magazine's Top Lawyer for the People in Trust and Estates in 2007. Mr. Tamborello's presentation today will be on the rights and duties of homesteaders, life tenants, remaindermen, and co-tenants. Please help me welcome to the stage Mr. Gus Tamborello.
All right, thank you, everybody. I've been here most of the day, so it's good to finally get up and be able to speak to you. So any of you that handle probate cases, or any of you that are non-lawyers that deal either in an accounting function or as trusts dealing with estates, know there's some kind of classic types of setups that lead to sometimes competing interests in estates. So, for example, sometimes a person will die intestate, as we know, without a will, leaving behind a surviving spouse who is not the first spouse, right? And children from another marriage. Classic setup, right? Well, it could be that the situation is a happy family, you know, Brady Bunch, that sort of thing. More likely, the kids think of new mom as the evil stepmother. You also have situations where a deceased person leaves his estate to someone other than his surviving spouse. Remember, Professor Beyer was saying freedom of disposition, right? You can give to whomever you want. Well, you don't have to give to your spouse. Of course, you can't give his or her part of the community, but you can give yours. And sometimes it's to someone much younger. Or sometimes someone much the same. So those are sort of another situation that could lead, of course, to conflict. The other classic biggie is a bequest to people with undivided interests. So we either have the children or perhaps the siblings if it's an unmarried person. And how do we deal with each of these having these undivided interests in properties? And that's going to be in the part when we talk about co-tenancy. Or what if somebody just gets a life estate? Or even worse, the dreaded life estate in 1/3, as it says in the Estates Code. And when they find out what a life estate in 1/3 is, the reaction is something like, surprise, surprise, surprise. So that's the setup. That's what we're going to now talk about. That kind of forms the outline of where we're going. So I want to first start then with the homestead. There's Barbie's dream house. But we all know that when there are competing interests, the dream house may not exactly be the dream house. So what is the homestead? Well, we're just going to talk briefly about it. It's really meant to be a place of residence to essentially preserve the family unit after the death, usually of the primary wage earner, is kind of where it began historically, so that they can at least have a place to live without loss or endangerment, preventing people from losing their homes. And if you guys remember, when the whole reverse mortgage thing started, there was a lot of concern that people would start losing homesteads because, as we're going to find out, there are ways to lose the homestead, even though it's granted to somebody at death as a matter of law. It can be a rural or an urban. If it's rural, it's a 10-acre tract. If it's urban, it can be up to 200 acres. Interestingly, there's been a lot of people who have claimed homestead in some maybe not so valid circumstances. We find that Noah's Ark was probably not a homestead because the homestead must be attached to land. And so a trailer, well, maybe not. Trailer house. How about a combination trailer and boat? Probably not. What about Buster Brown, who lived in a shoe, or perhaps the old lady who lived in a shoe? Probably not going to be considered a homestead because it's not attached to land. So, how does one acquire the probate homestead? Now remember, when we're talking about homestead right now, you can claim a homestead for tax purposes, but we're really right now talking about this right of occupancy, this right to live that arises out of the death of the decedent, and it's going to go to a surviving spouse or to somebody on behalf of minor children or both. And so that's really, it arises simply automatically if the person fits that status. So some might say, what if there was a divorce pending? Well, they're still the surviving spouse. You'll see that in heirships as well when you're trying to determine the rights of somebody that's a surviving spouse. And a lot of times the children from prior marriage will say, wait a minute, that my daddy was divorcing her. Well, it doesn't matter. As long as the marriage is still in effect, the homestead right kicks in. And interestingly, the homestead right will vest in the spouse or minor children regardless of the characterization of the property. So it could have been the decedent's separate property, and the spouse would still have the homestead right. It could have been their community property, in which case he or she has really two statuses. They're a joint owner and they have the homestead right. And we'll kind of see how that works a little bit more when we talk about the life estate. But essentially, that homestead right descends and vests regardless of this characterization. And now you can see where the competing interests begin to show their face, because let's say it was Daddy's separate property that he had with my mother, and now he's got wife number 2, and it's Daddy's separate property. We get it, right? That's what the estates code says. Ah, yes, but subject to her life estate, and on top of that, subject to the homestead right. So it's a very powerful right. What if wife number 2, after her husband dies, gets married? It continues into, it doesn't require her to stay a widow. She or he can remarry. And so that is also something that's very troubling to the sort of the heirs in waiting that are waiting to get at that property, because the surviving spouse can still claim it even if he or she remarries. But so what actually would finally terminate the homestead right? Well, we're going to talk about abandonment in a minute, but the real killer, no pun intended, death. Death will terminate the homestead. And it's at that point then that the kids who have been waiting in the wings could then come in and start to exercise their rights. We'll talk about that relationship when we talk about co-tenants in a few minutes. So the question is, what about the homestead being lost to debts? There are going to be some debts that can cause the loss of a homestead. I'm not going to go through them all now. There's a site in your paper, but it's the ones you're thinking of, the mortgage, the reverse mortgage, the home equity loan, those things that a security interest was given in the property. But for the general debts of the estate, it's not liable for it. And that's another thing that irritates some of the beneficiaries of the probate estate, is that generally that house cannot be reached for the ordinary debts of the decedent. Now, if the spouse had signed on, had joint liability for certain debts, that's another story. But if it's the decedent's debts, it's not going to affect her or the surviving spouse's homestead right. However, as with most things having to do with our friends in Washington, it can be lost, yes, to foreclosure by the tax lien filed by the federal government. So if our decedent failed to pay taxes, even if the spouse or the surviving spouse would not have been otherwise liable, he or she could lose her homestead to a tax sale, in which case then she would be entitled to her share of the proceeds, but she could actually lose. I say she, and I don't mean to be sexist, but the men usually die first, and so I'm just kind of going with the general rule, but I'll try to switch it up a little bit as we go along. But now, of course, she can agree or he can agree to voluntarily sell the property, and we'll talk a little about that when we talk about abandonment. I will say that a lot of the cases will say the rights of a homesteader are akin to those of a life estate. And we're going to talk separately about life estates, and you'll see very much similarities between the rights and the responsibilities. The difference is a life estate, true life estate, cannot be lost through abandonment, whereas the homestead, being the right of occupancy, can be lost. And it's that big factor that really distinguishes between the two. So when you see the cases saying it's akin to a life estate, it's not exactly a life estate. I chose the chuck wagon because we're in West Texas now, so it's what are the rights of the homesteader? Well, the rights of a homesteader can be substantial. And as I've kind of already been saying, the right of possession. And that's got to be Malibu Barbie, I'm pretty sure, that is on the couch. But she or he has the right to possession exclusively. And even though this may have been decedent's separate property, and maybe there's an intestate situation where the children from the first marriage inherited the property, they cannot take away the surviving spouse's right to possession until and unless it's terminated. So that's one huge right. The other, the right to the income of the property. And you think, income, what kind of income would you possibly have from a homestead? Well, remember I said urban or rural, right? Well, we're in Texas, right? That oil, Texas tea, right? That could be there. And the right to the income could be quite substantial. Generally, it's the right to the interest on the minerals, but under what's called the open mine doctrine, if there was already some oil and gas being produced on the property at the time of death, then the surviving spouse could also share in the royalties. If something happens to the property, she has a right to bring a suit for damages. That is a suit, ladies and gentlemen, of money. I'm not vouching for Miley Cyrus per se, but I will say that I liked her suit of money. So she could bring that. And the biggest protection is, as I mentioned, the kids can't come swoop in, so there is protection from partition. And so they cannot come in and partition the house. Only if she dies or elects to sell it or somehow abandons it can then partition be something that can be done. It's also not, as I said, distinguished by remarriage. But remember, it will die with her. So if she remarries, she doesn't necessarily lose the homestead, but it doesn't then extend to her surviving spouse. You follow me? So at that point, the kids could come in and, let's say, new husband of surviving spouse who's still living in that house of our decedent will then lose their rights. Okay, so we've talked about the main rights. Now, what are going to be the duties of the homesteader? One of the main ones is you have a duty to upkeep and do the ordinary repairs. So, and that mainly is kind of what you see. Now, of course, I think it goes a little beyond just vacuuming, but it could be any type of repairs necessary to the house. It does not necessarily mean improvements. So if, for example, you're putting this new wing on the house, it may not be something that in which you're going to have a right to because the improvements really require the consent of the owners itself. Now, again, the spouse could be both an owner and a homesteader. Then there's the payment of property taxes and mortgage interest. And that always surprises a lot of people that they would actually have to be responsible for the property taxes, which, as we know, can be somewhat substantial in this great state of Texas. And also, to boot, mortgage interest, which, depending on the type of note, could be extensive. This might result in this type of response. What you talking about, Willis? Remember the old Family Ties. What do you mean I've got to pay taxes and insurance? Yes, you might have to. You don't, though, have the responsibility for insuring the property as the homesteader. But what if you are on that note and you're a co-owner, say it was community property, you might have signed off on an obligation in the note to keep the property insured. But based on your status alone as a homesteader, you don't have the obligation to insure the property. And as I've said a couple of times, you can be found to have abandoned your homestead. And while that has people saying, surely you can't be serious, I would give up my home, I am serious, and don't call me Shirley. Anyway, yes, it's a little humor for Friday afternoon, ladies and gentlemen. Thank you very much. I'll be here all week. Be good to your waitresses. Anyways, yes, it's also a surprise to some, because let's say we do have the spouse who chooses to remarry. Okay, she doesn't lose the homestead, but what if she goes and moves in with new husband at his home? Well, you can only have the one homestead. Rural or urban, it's only one. And that sometimes is a problem, and it can result in abandonment. So how do you abandon the property? Well, abandon requires intent, and there's Patsy Cline with leaving on her mind. So she's got to intend to leave, and then some overt act, like abandoning it, leaving it, not coming back, obviously is going to be some type of abandonment. And so what the court's going to look at is not just physical absence, because you could leave for periods of time and still have the intent to return. It's when essentially you've walked away from it, abandoned it, not intending to return, and then perhaps, and the more common is, you've got a new homestead with your new spouse. Believe it or not, this is not mentioned in the articles, but it's mentioned in a longer version of this article, the published version. You can lose the homestead in other ways. One is if you murder your spouse. That one is probably not the Malibu Barbie, although I'm not sure. So Ken's having some issues there. But if you murder your spouse, but if you are just found to be insane, you might be okay, because remember, it required an intentional act. And that means, that you might not have acted intentionally in that case. So, before we wrap up homesteads, let's ask if the homestead itself has monetary value. Now, we know that a life estate does, and we'll talk about that in more detail in a moment. But it's interesting because the homestead is really meant to be some type of security more than an economic right. Remember, as we started, I said a place to live. And so it's mainly the value in it is seen as a possessory right. There's an interesting case that has come out out of the Fort Worth Court of Appeals in 2016 called N. Ray Sloan. And in Sloan, the wife passed away, and she left her home to her husband in trust, and with the understanding that he could buy the house out. So she buy her interest out in the house, or buy the house from the trust. And at some point, he decides to do that. And what he did was he traded 2 rent houses for the ownership of the homestead. And the value of those houses was calculated to be a little over $200,000. Well, then the husband dies, and the trustee looks back at the sale and says to husband's estate, "You didn't pay enough. You were supposed to pay fair market value for that house." And the fair market value was a lot more than that. The probate court in Fort Worth agreed, but on appeal, it was reversed. And the court said that, wait a minute, the rights of the owners was delayed as long as this guy was going to exercise his homestead right. And that delayed is essentially going to reduce the present value if you were going to sell that to a third party. And that makes sense, right? You're going to sell it, and you got to tell the third party, oh, so-and-so's got a right to live in it the rest of his life. It's going to affect the value. And so in that sense, the court said the homestead right actually reduced the fair market value of the property. And so that is something important to consider in negotiations, say, between the surviving spouse and the children. You see more of them trying to buy out the surviving spouse's life estate so that they can then do with the property what they want. But the homestead right is another powerful one that can be used as a negotiating tool. And now we see that it can be used in this way as leverage because it could affect the value that the spouse is being asked to sell her interest for. Okay, let's talk about life estates. That's really not the Malibu Barbie anymore. Barbie has turned 50, and now that I'm over 50, I kind of resent that, but you know. So a life estate, as we said, it can arise by somebody just willing, or deeding someone a life estate. But the more common one is the dreaded life estate in 1/3 that we see that somebody inherits under the estates code. And there is a death involving an intestate death involving separate personal property. So you can see there kind of a summary of the rights. I want to go into them a little more detail, and we'll see that the rights of the life tenant are similar to that of the homesteader. And while the life estate is not itself, the primary value may or may not be in the right to occupy, it does in fact give the right to occupy and possess. So there's Granny protecting the property, the mansion in Beverly Hills that they acquired. So she can, as part of the life estate, keep others off, just as she could do if she had the homestead. Now we're seeing here where it gets sometimes confusing to people because you could have the two rights going simultaneously. You could have the life estate that he or she acquired as an heir, being a surviving spouse. It could have been husband's separate property, and so she gets that life estate. But then there's also the homestead right, to live in it. There's a chance you get a life estate and you don't have a homestead, or there's a chance you'd have a homestead and there's no life estate. But they could run concurrently. So the right to occupy is important. Another biggie is you can sell that interest, and so that sometimes has some value. And what we'll see in these mediations involving, our first classic scenario between the children of the first marriage and the surviving spouse, an attempt at buying out We want a divorce now, stepmother, and we want to get this property. Well, as you can see, that has some value. We'll talk about how that's calculated in a minute, not in great detail, but that does clearly have value separate. It's not the same as, looked at the same as a homestead, because this is an actual interest in property that does have monetary value, and we'll see it's based on the value of the property and the life expectancy of the person. And again, remember I said the whole income and profit thing, which you think, well, what if, what kind of income are we talking about? Well, I mentioned the oil and gas, but let's say the separate property was not the homestead. Let's say it was our deceased person's, some type of a commercial property that's been leased out to some business, and it's throwing off rent. So income, of course, is a huge part of what are the rights of the life estate. Okay, so we talked about the rights. So now, what are the duties of the life tenant? Well, not surprisingly, they have to upkeep and repair the property, unlike Our Lady here, who might just be allowing the property to waste, which is a no-no. So you've got to upkeep the property. You can't damage the interest of those waiting in the wings. So now, we have the Remaindermen, which we'll talk about in a minute, that are waiting there. The other, again, let me just say this about insurance. Again, no duty to insure the property. That's going to be generally the obligation of the owners. And more likely, if you just have the life estate as a surviving spouse, you likely don't have the community property interest, because you wouldn't have gotten the life estate unless it was separate property of the deceased. The biggie, of course, is, wait a minute, I have only a life estate and I have to pay taxes? That's correct. There is liability for taxes, and as Barney Fife would say, we need to nip that in the bud, Andy, because this is a huge deal. And think about it. Wife might have been a stay-at-home person, or husband might have been a stay-at-home person. The wage earner is now deceased. And yes, I have these rights to live in this property, but now I've got these expenses. So we know about taxes. There's that mortgage interest. I love that expression. They can't be serious. Okay, one more time for Friday. I am serious. And don't call me Shirley. And here's what I was referring to earlier, committing waste. The problem is the life tenant can't, although they can kind of treat the property as their own, they can't really let it go to shambles. And what is waste? Well, one case defines it as permanent harm to real property by the tenant for life that is not justified as a reasonable exercise of ownership and the enjoyment, and that results in a reduction in value of the interest of the remaindermen. This probably is a reduction in value, I would say. This probably constitutes waste. So it's something then that a life tenant, again, has to be cognizant of, and again, have the means to keep up the property. And you can't let it get taken by forfeiture. You have to do what you can to reasonably preserve the property. So how do we value a life estate? As Barbie says, math is hard. Now, some of you in here are math people, and you'll salivate over this one. But it's on page 14 of your article, and I don't really have the time to walk through it in detail. But what you do is you determine the value of the property and then the life expectancy of the life tenant holder. And then you go to your handy tables that are set out in the IRS publication 1457, which gives the actuarial factors. And then you actually put pen to paper and you determine an interest. So unlike the homestead, which might be kind of negotiable, a life estate, it's fairly not easy, but there's kind of a formula to get to that value. And one of the ways, as I've mentioned, that we see these cases getting resolved is there's some type of a buyout. But then there's that weird thing, the 1/3. And there the banana is split into 3. What do I do with a 1/3, and where the heck did this 1/3 come from? Well, I actually found this article that said it actually came back all the way back to the Code of Hammurabi. Wow. And it used to be that the surviving spouse was not an heir. So see, ladies, a lot of things have changed for the better, and now you went from nothing to a life estate in 1/3. I say, ladies, men too, if you're the surviving spouse. But what they used to get was something called dower. And dower was essentially a 1/3 interest. Where they got that, I don't know. But when the Muslims then conquered Spain, it became part of Spanish law. And then guess what? Guess who was part of establishing Texas, right? The Spaniards. So somehow, when you look in your little estates code and you see this life estate in 1/3, which the law students that I teach say, what the heck is that? And it's not that easy to explain. Life estate is. So the third is essentially, it's a mathematical calculation at that time, at that point. And so, there's some citations for you in the article about some cases that talk about division of proceeds. But when it comes to the income, then it appears the law supports dividing that by 1/3 if that's the extent of the spouse's or the owner's interest in the life estate. So if you have a life estate, then you have the Remaindermen. And there they are, ladies and gentlemen, the Remaindermen. And who are they? Well, they're the owners. These are the ones who don't like the evil stepmother or the evil stepfather. These are the ones waiting in the wings who actually own the property subject to the life estate. And what is their rights? Well, one of their biggies is, of course, the right to sell their interest. And again, it is an ownership interest, and so it does have value. And it, of course, they have to factor in, the buyer will, of course, that it's subject to a life estate. And so it could be that surviving spouse might try to buy out, maybe he or she wants to stay in that house, and they buy them out of their remainder interest. So we'll see, you go to the same table in the IRS code, and you can value the remainder interest as well as the life interest. But as I mentioned, the homesteader and the life tenant do not have to pay the insurance. The burden of paying the casualty insurance is on the underlying owners, which are, of course, the Remaindermen. And another biggie is the mortgage principal. So again, depending on how big the mortgage is, it's no small task for these Remaindermen who just inherited daddy's property, not only subject to a life estate, and now we've got certain ongoing obligations. Well, guess what? You're an owner. You didn't have to say yes. You could have disclaimed, I guess, if you didn't want the property. But if you want it, you inherited, there are responsibilities that go with it. And again, because of that, those responsibilities, it's ripe for some type of family settlement agreement for people to kind of cut a business deal and try to not necessarily reconcile with their stepmother or father, but somehow work a family settlement that involves then outright fee simple ownership one way or the other. Other than having those rights and duties, the Remaindermen just have to wait. And so that is kind of the hardest thing for Remaindermen to do. So finally, we talked about the scenario of the surviving spouse and the children from the prior marriage. And we've talked about a situation where maybe someone just inherits a life estate. Now, what happens when the life estate terminates? Well, we know then the remaindermen can go get it. Same with the homestead. Once homesteader dies, then or abandons or sells, then it's, well, or sells her interest, it's now owned by whoever the underlying owners. And remember, one of our early slides we have these co-tenants. And co-tenants are usually brothers and sisters. And we all get along with our brothers and sisters, correct? Yes. Well, I have 3 older sisters, so I like to tell everybody I grew up with 4 mothers, and that's not always a blessing. My dear 86-year-old mother, I do call every morning, but my sisters and I, we get along great. It's one of those things where you can be mean to your sister, but nobody else can, right? You're going to defend them, but you fight amongst yourselves. I'd like to think in my family we're not going to have this feud over money. But guess what? Normally after, daddy dies or mama dies, the kids kind of keep it under control until the second parent dies. And then now these people own this property together as tenants in common. And sometimes it could be like Three's Company because they have an equal right to possession. Well, how does that work? Well, sometimes it could be a full house. Thank you very much. Another little... I was definitely a child of the 70s with me, the sitcoms, for sure. So, is it going to be a happy family like that? Probably not, folks, right? Because usually one of them is going to want to live there. Mama told me that I could always, live there. Oh, really? That what she told you? Did she put that in the will? No, she didn't, but y'all know that. Or one kind of takes over and starts to do what they want. And one of the things they have a right to is, of course, to possess, but also to kind of hang out without paying rent. And that's probably Malibu Barbie again, I would think, at this point. But they're hanging out, and they don't have to pay rent unless somehow they attempt to kind of oust the rest of the family. And then at some point, there could be a squabble over how that interest should be compensated. One of the things, though, if you are living in the property and you do make repairs, you do have a right to reimbursement for making the repairs. If you start to make improvements, it's the similar problem that a homesteader and a life tenant has. You may or may not receive compensation for that. So because they're co-owners, you've got to get everybody in agreement. And we know how hard it is to get more than one person to agree to anything. But that's a powerful right to be able to occupy. But the most powerful right is the right to split Barbie's dream house into 2. Well, what if it's an urban homestead? You can't very well split the 2,000 square foot home, the 3-bedroom home, 5 ways, can you? So what's the bargaining power? I can force a sale of this property. Now, remember, while surviving spouse or the owner of the homestead right or the life estate was living there, they couldn't do anything. All bets are off now when they are merely co-tenants. I say merely when they don't have any superior rights over the other at that point. And so there are duties, of course, of co-tenants. And you can imagine when there are multiple owners, you're going to have certain duties. And one of them is to preserve the property. Yes, you have to treat it like home sweet home because you're not the only owner. And so you are multiple owners. And even if one person is using the property more than the others, it doesn't give them greater rights. They still have to preserve the property. In addition, they have to account to the other owners if they are renting the property. There's no right for the occupant at that point to take all the profits. Notice the difference now between the rights of co-tenants that are all equal owners versus if one of them had a homestead right. But interestingly, remember what I said, the homestead right of the surviving spouse extinguished, and then their right to possess kicked in. But one of those co-tenants cannot then claim homestead and say, sorry, fellas, I'm also a child of the 80s where Beavis and Butthead was popular. We can say Butthead, right? Because somebody else cussed already, right? That is, you cannot exclude the other co-tenants. One of the ways you would exclude them is attempting to try to assert the homestead right in it. And you cannot, that's now even before the 70s. Now I'm really going across the board. You cannot treat the property in such a way as to deny the other co-tenants their rights. So essentially, where have we gone now in this little journey? So we talked about that scenario where there's a surviving spouse and children from the prior marriage. We now kind of see how that all can work out. We can see the competing interests, and it's ripe for some type of resolution. Then we can see what happens when there are co-owners of property. And all of these beg for some type of resolution. But they are significant issues to be dealt with in the probate process, and essentially also for those of you who are the financial people in dealing with the value of those interests and how we sort of negotiate that. So with that, I'm going to conclude as the words of Elvis. Thank you very much. Thanks.
Thank you, Mr. Tamborello. Our next speaker is Miss Lora Davis. Miss Davis is a founding partner of Davis Stephenson, PLLC. She focuses her practice on providing extensive estate planning services for individuals and multi-generational families and assist in implementing strategies that will preserve, protect, and transfer assets consistent with each client's customized plan. Her experience includes preparing a wide variety of estate planning documents, handling issues involving the Internal Revenue Service, and assisting clients with charitable planning, probate matters, fiduciary litigation, the creation and administration of business entities, transfer tax planning, and marital property issues. Ms. Davis is a magna cum laude graduate of Southern Methodist University, Dedman School of Law, after receiving her bachelor's degree from East Central University in Oklahoma. Ms. Davis is also a CPA in both Texas and Oklahoma. Ms. Davis is the recipient of numerous recognitions, including the only Dallas attorney specializing in estate planning, selected by her peers to the top 50 women lawyers in Texas and to the top 100 lawyers in Dallas-Fort Worth lists. Ms. Davis will be presenting on tackling estate tax returns and related forms. Please join me in welcoming Ms. Lora Davis.
All right. Hope you guys can hear me okay. I decided not to wear the mic. I've had a lingering cough, so if I have a coughing attack, I'm going to turn away so you guys don't have to hear it. First of all, I want to thank Texas Tech for their fabulous hospitality. This has been wonderful to be here. It's my first visit to Lubbock, and it's been wonderful. They forgot to mention that I'm a huge college football fan. And so my theme here is 56, 706, 5495, 8971, HUT. So I'm here to talk about several forms and Probably the 706 is one of the forms I'm going to talk the least about. It's probably the one that you're most familiar with, so I want to spend my time kind of going through all of the other forms that you might want to prepare for a 706, and then of course the 8971, which is the basis consistency form. Even if you never prepare a 706, this is a form that you need to be familiar with and understand because it affects every beneficiary in Texas. All right, so first of all, we're recruiting our football team. And before I hop into this, I have a really dry tax topic. So if you haven't eaten your cookie yet, you can go ahead and unwrap it, and you might need some sugar later on. But we're going to get through this, hopefully. So you've got your team. If you're a CPA who prepares returns, or if you're the lawyer who prepares returns, you know you're not the only one that's the member of this team, so you can get it across the goal. You want to get everybody together and make sure you have all your players. You need the lawyer, you need an accountant, you need your financial advisors, and certainly you also need business associates and partners of the decedent and family members to help gather all the information that you as a professional might not have. And it's key then when you get a big group like that you want to make sure everybody knows what their roles are. Because sometimes when you have a group, everybody says, oh, so-and-so is doing it or so-and-so is doing it. So you got to make sure that everyone knows what their role is and they're appreciated and needed. And you all want to be singing at the end, we are the champions, right? You want to be rocking that 706. So here's the game plan. These are all the forms that you might want to file in connection with an estate tax return. We're going to walk through this 20 forms. Seems crazy. About half of them are what we might call the warm-up or the beginning forms before you even get to the 706. So let's take a look at some of those. The application for EIN, you guys are really familiar with this. You used to be able to have to mail it in or fax it. You can still do that, but mostly it's done online. And for the most part, that works well. They shut it down at the end of the year when you most need EINs, and so that doesn't work so well. Just some things to note about this form that you might not know. If you've got an existing revocable trust and you want to make a 645 election, which is to treat the estate and the trust as one for tax purposes, you need to go ahead and get a new EIN. You cannot use the current existing EIN that you have. You also want to pay attention when you're getting an EIN for an estate to whether your decedent was an employer. And if he or she was, if the estate is now going to need to be an employer. I think most of us practitioners sort of skip over that part because there's never employees for the trusts we create. But this is one that you might actually need to pay attention to. And then another sort of practice tip is the third-party designee. On the bottom of the actual form SS4, there's a little third-party designee, and your client can designate you as the person to get the EIN. And most people will fill out the SS4, and as good practice, you should have your client look at it. So the client here would be the executor, make sure everything is right, sign the form, even though you're going to be applying for it online. Well, unfortunately, there's a little bit of a disconnect between the form and the requirements for the form. The form on the third-party designation says that you can talk to the IRS about the form, but it doesn't say that you're authorized to get the EIN on behalf of the client. So if you're preparing these and getting these online for clients, you need to have supplemental language that you have the client sign off on that says, I'm authorizing you to get this. Now, I've never been called by the IRS to say, hey, show me this and make sure you have it. But just as good practice, if you want to make sure that you're protecting yourself from liability and your ethical duties, because I think I'm giving credit for ethics here. So we're going to talk every now and then about ethics. This is something you need to pay attention to. There's some language in the outline that you can use if you haven't already been using it. And then the one glitch that we all know about, you can only get one EIN per day per responsible person. So keep that in mind. If you have a trustee of several trusts, you might just have to stretch them out over several days. All right, the next form is Form 56. A lot of us don't file this form because you don't have to file it. And as soon as you file the estate tax return, that gives the IRS notice that the executor is acting on behalf of the estate. But you might want to consider doing it for other reasons, particularly if you're going to extend that 706. And so now you're 15 months out and you're acting as an executor for the estate. There could be some issues that come up with respect to the estate, and you want the IRS to know that you're the fiduciary so that nothing gets dropped in the gap. The thing to note about the 56 is that you do have to have separate forms with respect to each person and each type of tax. And also, probably the biggest thing to know about Form 56 is that you also use it to notify the IRS of a termination of a relationship. So this is really important if you represent a trustee or an executor who gets fired. You want your trustee or executor to file that form so the IRS doesn't continue to send stuff to them and think that they're responsible for that estate or trust. Now, what if you need forms? So you've got, with your estate tax return, you have to file the previously filed gift tax returns. I don't know about you guys, but sometimes we have clients that don't know where they are. So what you will use to get those returns are this 4506, and you see 3 up here, 3 different ones. The 2 first ones are the ones that you might want to use, and actually you might want to do both, because the 4506 is a request for an actual copy of the whole return, and if you need a copy of the whole return, you better plan ahead, because it could take up to 75 business days to get it. And then it's possible that after you've requested the return and you've waited all that time, the IRS will come back and say, oh, couldn't find it, sorry. So the other thing you can do is go online and just get the numbers. So the 4506T is something you can go online, it's free, you can get it right away, and you can request a return transcript, which is the line items from the return. It's not an actual copy of the return, but it gives you numbers from different lines. You can request the account transcript, which tells you about the payments and the penalties with respect to the account, and you can get both, which is the record of account. Now, the only thing that this will not give you is if there was an audit or a subsequent adjustment, it's not going to show up on this. You'll want to get that on the request for the copy of the tax return. And also, one thing to note, the IRS had some problems of hacking into this, and they had to pull it offline and refortify it. Hopefully it's up and running. I actually didn't get to try it before today, but I think that's one way you can use to get forms easily, or get information at least for your return. And now we have the application for extension. I think most people, when they're filing a state tax return, inevitably have to extend it. And so this is asking for a timeout on the field, right? Okay, wait, we're not ready. We got to regroup. We got to still gather our information. So it's an automatic six-month extension. Even if you write a love letter to the IRS and say, pretty please, will you confirm that you've received my extension? They won't do it. So don't waste the postage and don't waste the extra copy. Just send it in and keep proof that you've mailed it. And then a question arises what if you filed an extension because you weren't really sure, maybe you were going to file a portability return, and then ultimately you decided you weren't going to file it? Well, interestingly, the instructions say that what you need to do is send a letter to the IRS and tell them that you're not filing and attach a copy of your probate inventory and appraisement. I guess they wanted something, but as we all know, that sometimes is very different from what the estate is. It's not all inclusive. And so I don't know that the IRS is going to track you down, but it's likely that if you file an extension and you never file a 706, you're going to get a letter from the IRS saying, where's the return? So even if you don't want to give the IRS a probate inventory, you should do some kind of communication to say, hey, we filed this extension and now we're not going to file a return because none is required. And then also on the extension, you really need to file it on time. You can get if you file it late, you might be able to get an extension, but you have to have good cause. And if you want an additional extension after the 6 months, you can request it. And one of the reasons they give that is a legitimate reason is if your executor is out of the country. Now, this can't be someone who's just cruising down the Caribbean. You need to file it well in advance, and they're out of country for some legitimate reason. I think there even maybe was something that said vacation is not legitimate. So keep that in mind. Be sure to be prepared to get that filed timely. Now, these are the forms, 8822, that gives a change of address. These would be good for the CPA if you've got an accountant involved to prepare, because they're the ones that know what addresses are on the accounts for the various compliance. The change of address 8822 is for kind of a personal taxes, and it's not required, but it's sort of helpful to file, just like the notice of fiduciary relationship. You want the IRS to be able to get communications to you. You don't want it to fall in a black hole somewhere and then you start accruing penalties that you're not aware of. The 8822B is a little bit different because that's with regard to business responsibilities. And so if a decedent was a responsible party with respect to a partnership or some other kind of entity, or if they have household employees, or if they're a trustee of a trust, you want to make sure that the IRS knows there's actually a requirement that you have to file this with the IRS. Now, there's no penalty if you don't, and I don't know that the IRS is enforcing it. But again, if you're going to practice ethically, you would be making sure that you do this every time. And there's also the 8855. And this, again, is the something good for the CPA to do because it relates to taxes, and they're going to do a lot of analysis to see what makes sense if you want to make a 645 election to treat a trust and an estate as one during the administration. One interesting thing to note on this, I'm not going to spend a long time talking about it, but the executor is the person who makes it. So you've got a trustee and an executor. It's the executor that makes the election. But if for some reason, and I don't know about you guys, but I have a lot of people talking to me, oh, that evil probate, I got to not have probate. I want everything into my revocable trust. You say, okay, we'll try. We don't know if we can get it all in there, but so you've got the revocable trust, and your client dies, and you said, okay, everything, we've assigned everything, and everything's titled, and we don't even need to go through probate or get an executor. So you're going down the path, and the trustee can then make that election. But then lo and behold, you're about 9 months into it, and you find an asset that requires you to have a probate. And it's something that you can't do a muniment of title, so you have to go and you get your executor appointed. Well, once the executor gets appointed, the executor actually has to make that election. And if the executor does not make that election, then it's considered revoked. It's deemed terminated the day before the executor gets appointed. So that's something that may not come up very often, but if you see it in your practice, just tuck that away way back there and say, oh, wait, we've got to make sure to do this, particularly because a lot of that happens on the attorney side of things, and if you've got the CPA who's doing the 645 election, they may not realize that now we've got this extra probate thing happening, and we've now are getting an executor. So that's something really important to keep in mind. And then finally, we're here to the game, the 706, which is the key form that everyone thinks about when somebody gives a talk on estate tax returns. And I'm happy to direct you to the outline. There are great outlines that already exist with respect to filing estate tax returns. And if you're a member of the State Bar College of Texas, you can access all of them for free on their online library. If you're not, you might actually want to join that. It's a great organization. It gives you access to all the great outlines from Texas presenters. Oh, and I also have, if anybody wants to look at this later, it's a fascinating read. It's the AI CPA playbook for filing estate tax returns. And it's a checklist, and I think it's maybe like 50 pages or something. I've printed it in really tiny. But this is their guideline about things that you need to check when you're doing a 706. What I will point out to you, just a couple of things. One is read the instructions. I know they're really lengthy, and you don't have to read them all, but you should read the instructions at least once a year, because the IRS will go in and update the instructions. And they'll put a what's new section, but that what's new section does not actually say everything that's new. It sort of highlights what they think is important, but they may change something that you have always reported partnerships in this one way, and they may make a change in the instructions and not highlight it. Well, you may not know that until you go back and just refresh your memory as to what the instructions say. Also, you should be sure that you're filing a complete and proper return. Now, that concept, I think, has been around forever, and ethically you all want to do that, but particularly with portability, that came out. People asked, hey, do we have a 706 light? I said, no, Miller would not sponsor it, so no 706 light. The IRS said, we're not letting you do that. We want you to file a full return. There's no shortcuts. So when you're doing that, and keep in mind, you still have agents who are picking up this paper return because it's not electronically filed. They've got this return in their hand, and they're flipping through it. So check all your numbers. Make sure your math is right, because as soon as somebody sees that the math's not right, they wonder what else is not right if you can't even get your math right. So that's one thing. And then make sure you're complying with all the rules and requirements. There's some really arcane requirements, and I think a lot of people don't pay attention to them. But if you do, the people at the IRS, I mean, I'm a tax nerd, I really am, but the people in estate and gift, they really are tax nerds. And if they see that you've actually verified all the trust agreements that you've attached, or you've had your executor sign that under penalty of perjury, that the appraisal of that tangible personal property is proper and you believe that it's accurate, all of that goes a long way to say, wow, they really cared about getting this all right. And if you're prettier than the return sitting next to you, that's good. The other thing that you need to remember is that you're not going to get a closing letter. So no, they're not going to send it to you, although I have a friend in Arizona that filed a portability return and got a closing letter unsolicited. It must have been some kind of renegade agent doing that. I have no idea. But now, if you want to get a closing letter, you have to either get a transcript to request that to see where it is, or call. And I think hands down, everyone said, shockingly, that it's easier just to call. You can actually get someone to answer the phone, and they usually will tell you the status of the return. So I recommend you should get a closing letter, and the best way to get it is by calling. And the 706NA is for a non-citizen, non-resident spouse, has special rules. We'll skip past that. So here's some forms that you will file with your estate tax return. One is a 4808. I'm sure you're all familiar with that, right? Everyone's seen it? I actually could not find it when I was first preparing this paper. It has to do with pre-77 federal gift taxes paid. So it's not going to come up very often, but it was so curious to me because it's actually mentioned in the instructions. So my friend Bill Pargaman, I said, if anybody finds it, let me know. So if anybody is going to dig and find something arcane, it would be Bill. And he did. He found a copy of it. It's not on the IRS website, but it's out there in the big, bad internet. And I think I have a link to it in my paper if you want to find it. But nonetheless, if you have that circumstance, there's a way to calculate it, and you don't have to find the form. But in case you have it and you start looking everywhere for that form, there's a link in my paper for it. And then there's probably what your executor most importantly wants you to file and doesn't know about is the form 5495, which is the request for discharge from personal liability. And that's a form you can file to get request a discharge from that personal liability for either the executor or the trustee for income, gift, and estate taxes of the decedent. So you can file that with the estate tax return, but it does have to be filed after the filing of other returns, like the income tax return and gift tax returns. That's an important form that your client will appreciate you knowing about and using. Other forms that you file, power of attorney. Everyone's familiar with that. You can list up to 3 people, up to 2 people can get notices. Another form you might not be as familiar with, and that I actually find pretty interesting, is the 8821. On the power of attorney, you're actually designating individuals. On the 8821, you can designate a whole firm. So let's say the accountant is handling all the tax filings, but the lawyers want to be kept in the loop even though they didn't prepare it. So the CPAs can be on the 2848, and the attorneys, a law firm itself can be designated on the 8821. And then if Joe Smith, the lawyer, leaves the firm and somebody else comes, you don't have to do a whole new form. The law firm will still continue to get those notices. That does count towards your 2 representative notice limit, though, so keep that in mind. If you're using that form, your power of attorney can only include 1 notice beneficiary. And just when you thought you were done, because you filed the return and everything looked good and you all celebrated finally getting it out the door, now we get overtime, forced on us by the IRS. It's unfair and awful. But actually, it was not the IRS that did it. I have a soft place in my heart for the IRS. This was Congress. Congress did this. They said, you know, we need money, basically, in the highway bill. And ever since 2009, the Obama administration said, this is a way to get money. We're really worried about the fact that we're getting whipsawed on basis. People are taking a low basis for estate tax return purposes, and then when the beneficiary gets the asset, they say, oh, it was worth way more than that, and they use the high basis when they sell the asset for income tax purposes. And I'm not sure how they even guesstimate what the numbers are, but there were some pretty large estimates of how much money this bill would raise. So it kind of gets stuck in there. And in our current Green Book, which is still the Obama Green Book because we don't have one from the Trump administration, it recommends that we include marital and lifetime gifts in this regime. Right now, those are not included, but I think just from my rough math, if those provisions were added into what we have right now, that would raise $1.5 billion in revenue. And I know we have a Republican Congress and a Republican administration, but that's not really a raise in taxes. I think that this is something that we all need to be looking out for because this is money that's available for all the programs that people want to fund. So it'll be interesting to see if that comes around. So with the new highway bill, what we got was Section 1014F, which is the basis consistency rule. We have Section 6035, which gives you the reporting requirements, and then that very well-known 6501 E1B2. I know you guys love that. You say it every night before you go to bed. Well, actually, that's one you need to sort of be aware of. It gives the IRS an extension on the statute of limitations to 6 years if you have an overstatement of basis that results in an understatement of gross income, even if you have adequate disclosure. So I think we all feel pretty good about, I'm going to disclose that I'm using a different basis, and the IRS has 3 years to come and get me, and once that's over, I'm good to go. Well, that's not true. There's a longer period of time under 6501. So take note of that. This was effective July 31st of 2015. Shocking, since we're already in 2017, and we don't really know what we're doing still. So let's talk about 1014F. That's the basis consistency rule. And it says that the initial basis of your property that you get from a decedent can't exceed the value that was finally determined for estate tax purposes. Now, this only applies right now, unless the law changes, to property that increased the liability for estate tax. So that means it won't apply to a marital gift or a charitable gift, and it won't apply to any amount that was sort of a formula to get you to a zero tax estate. Now, 6035 tells you how you have to do the reporting. Now, if I accidentally slip up and say basis in connection with this reporting, I don't know if any of you guys have been in Toastmasters, if you got a horn or a bell or something, you can, or throw candy at me or something, but this is not basis. This is reporting value. It's reporting maybe initial basis, but all you're doing is saying what the value was as reported on the 706. So the executor files with the estate tax return, or after the estate tax return, an information return, which at the time that they had prepared these regulations, they didn't even know what the form number was. We now know that that's 8971 and Schedule A. And Schedule A is the statement that the beneficiary gets. The key to remember is that reporting is required even if there's no basis consistency duty. So remember I said the marital and charitable gifts, you don't have to follow the basis consistency. You still have to give them that Schedule A report. And I think that's counterintuitive, because why would you have to give somebody a report for something they're not required to follow? And really, I think it's because they're preparing for a change in the law, and that reporting system will already be in place. So here's the IRS showing a lot of love for us practitioners. When the law first passed, the first deadline, it's 30 days, after your estate tax return is filed. They gave us an extension, and that was really because there were no forms. But still, then they gave us another extension, then they gave us another extension. So all in all, we got 3 extensions, and then we thought, maybe we'll get another one. No, there were no more extensions. That was all we had. And so now all of the returns were due that had kind of piled up and not been due were due on June 30th. Now they're due 30 days after your 706 is actually filed. So I'm not going to go too much into this slide other than to say, you know, the way that we got the form and instructions with the IRS really kind of hurried to get all those out. And then we got some proposed regulations, which people had a lot of heartburn over. ACTEC did a really extensive comments on those regulations. And then in June, the IRS, without any kind of hoopla, just gives new instructions and Schedule A. And they don't highlight what they've changed, they don't say what they've changed, but what they did do is they said you could not have any attachments whatsoever to your Schedule A. You know, how do you do that with an estate tax return? So there was a big public outcry about that, and I think it was because a lot of people said, oh, well, I'm going to just take my 706 and clip it to my Schedule A and say, see attached. Well, the IRS was saying, no, that's not completing the report that we need. So then the public hearing that they had on the regulations was very interesting. There were a lot of organizations that went. I was there on behalf of the State Bar tax section, and I think the IRS was open to some of the suggestions that we made, mostly because they were scurrying around trying to figure this out at the same time that we were. And then after that, they gave us some new instructions, and the new instructions said it deleted the prohibition on attachments. So you're allowed to attach things, but they had some specific rules about what you could attach. So they said if you can have an attachment of related property, like stocks in a single account is one of the examples. So if you're going to go get your estate valuations, you should do them account by account. And they also said we don't want a lot of extraneous stuff on those attachments. So if you've got your stocks being valued on estate val, you should export that report to an Excel spreadsheet and take out all of the references, the high and low and all of that, because they don't need any of that. All they want is the name of the stock, and they don't want the QSIP number. They don't need any of that. They want the stock and the value. So at least now we know that you can at least attach that and not have a return that's not properly prepared. As I said, initial returns were due by June 30th, and now it's 30 days. The 8971 is just an informational return. It just has information about the beneficiaries and the executor. You should never give that to the beneficiaries because it has confidential taxpayer identification numbers on it. And that report does not have any values. The Schedule A, on the other hand, is sort of like a K-1. It includes the beneficiary's information and values, and each beneficiary gets their own. Now remember, we're not reporting basis. Maybe you can say initial basis, but we're just reporting value. And just a little side note here, I guess, from an ethical standpoint, what do you do? Because you're giving somebody this report that could have completely meaningless information if you've got adjustments to basis during the estate administration period. Keep in mind that, generally speaking, you as an attorney are representing the executor and not the beneficiaries. So you have to be a little bit cautious and careful about advising beneficiaries, but you also are the only one with the information that could be available to them. So it's a fine line to walk, and I think people have taken different sides. Don't say anything, say consult your own tax advisor. And some people say, no, I'm going to include a statement that says that was the initial basis, but here's what's happened during the estate administration, so here's your new basis. I'll leave that up to you, but in any case, you should consider your approach to it instead of just sort of defaulting into nothing at all. All right, so who files it? It's the executor, and it's for a taxable estate. So if you don't have a taxable estate, you're not required to file it. If there's no executor, it's whoever's in constructive possession of the property. So it could be more than one person who actually files it. And then excluded are the returns at the bottom. Portability returns, there was some question about it because it wasn't clear, but in the last round of instructions, they clarified that portability returns don't require this filing. So who's the recipient? It's all of these parties, even the surviving spouse and charitable beneficiaries, like I said, even though they don't have to report. There's some other sort of questions. One is if you have a trust as a beneficiary. So you've got an estate, and it says, send everything I have to my revocable trust. You know that your revocable trust is not going to continue on. It's going to then maybe disperse out to some people and disperse out to some other trusts. But I think the regulations at this point are very clear to say if assets go to a trust, you give the notice to the trustee. Now, I know some people differ in their approach to that, and they say, well, the revocable trust is really, that trustee is really more like an executor, and I should give it to the subsequent trust because that's really what the statute is trying to get to. And I agree, that's what the statute is trying to get to, but that's not what the clear language of the regulations say. So again, we're got some uncertainty here. You guys should just decide what approach works best for you, and whatever you do, disclose what you're doing so the IRS understands and knows it. There's some problematic issues with missing, unknown, uncooperative beneficiaries. You have to use reasonable due diligence to track people down, and you should document what that due diligence was. And you should, if you haven't found somebody, or you know who they are but you don't have their address or you don't have their social security number, you should attach to your forms that you file with the IRS, here's all I did to try to track them down. I'm not a slacker executor. I really am trying, and I couldn't find it. So what gets reported on Schedule A? Basically, it's all the assets that were on the 706 and are distributed to a beneficiary. So that's interesting. You've got a big stock portfolio, and during the state administration, you've sold some and bought some, and you've got a different, and then you get, you file your estate tax return. Now you're trying to figure out, what do I have to report? Well, you only have to report what was held at date of death. You don't have to you report new stocks that were bought unless their basis is determined in connection with existing assets of the estate. But it could be a nightmare to parse all of that out. So really, there's no harm in over-reporting from the IRS's standpoint. There might be from your beneficiary standpoint, but from the IRS's standpoint, there's no harm in over-reporting. And I think what a lot of people have done is just said, I'm just going to, if those assets go to a beneficiary, I'm just going to report everything. Just better safe than sorry. And then what do you do about undistributed assets? So in most estates, by the time you file the estate tax return, you haven't funded any or very many of the bequests and funding the trust because you're waiting. You want to get your closing letter. You want to make sure everything's filed right. Well, the IRS has this sort of kitchen sink approach. They say anything that could be distributed to the beneficiary gets reported on the schedule. So that's all fine and dandy if you've got a surviving spouse. Yeah, sure, just report it all. It doesn't matter. But let's say you have two siblings that do not like each other. Gus and his siblings, I guess. I don't know. But let's say you've got siblings that don't like each other. And so then you report everything to both of them. Ultimately, when you go to make the distribution, one of them is going to be mad that they didn't get that asset. Why? You said I was going to get it, and I didn't get it. The Texas tax section, as well as ACTEC, took the position there should be sort of two options for that kind of reporting. You should be able to either report it all, or you should be able to wait until you distribute the asset, because the beneficiary is never going to need that basis information until they actually have the asset in their hand. We're still waiting with fingers crossed to see if they'll do that. But for now, you have to report any asset that could be distributed. So here I have a little heart on my notes, feeling the love from the IRS. They gave us some exclusions and exceptions. They're being pretty nice. They said there's certain things that you just don't have to report because we're not worried about basis. Cash, right? So on its face, cash seems pretty easy. That's the stuff you got shoved under your mattress, or the stuff you had in your wallet when you died. But what about money market accounts? Is that cash? Yeah, probably. What about CDs or foreign currency? Life insurance proceeds, tax refunds? They all get paid in cash. They seem like cash, but they're not immediately cash, so it's not sure if those are exclusions or not. What about notes receivable? Mostly they're reported at face value. But I do know of a note, and this had to do with a loan that was made at a bank, and it was Kermit Jagger went into the bank, and he asked the banker, he said, "What's your name?" And she said, "Well, I'm Penny Black." And he said, "Well, I'm Kermit Jagger, and I would like to get a loan." And she said, "Wow, are you any relation to Mick Jagger?" He said, "Well, yes, that's my dad, but I don't want to borrow any money from him. I want to get a loan from the bank." And she said, "Okay." She took some information from him, and she said, "Well, we're going to need some collateral." So he gave her this pink ceramic elephant trinket. She said, "Okay, well, thank you, Mr. Jagger. Let me go talk to my manager about this." So she goes into her manager and says, "I got this frog in my office, and his name is Kermit Jagger, and he wants a loan. He's got terrible credit, and I asked for collateral, and he gave me this thing. I don't even know what it is." And he said, "Well, that's a knick-knack, Penny Black. Give the frog a loan. His old man's a rolling stone." Sorry, we're a little... I love corny jokes and puns, and so I've just kept it down to one, so that's pretty good. Anyway, suffice it to say, there's things that may seem like they're cash, but maybe aren't cash or aren't worth what you think they might be. IRD, the same thing. Maybe you've got an IRA and you think it's all IRD, but maybe it's not. And all of these other assets, there's problems in the regulations with regard to property that's sold in which a capital gain or loss is recognized and the asset is not distributed. What if you didn't have any gain or loss at all? Does that still qualify? What if it's an ordinary gain or loss? And so there's some holes there. I think, like I said before, you just want to over-report if you're not sure. It doesn't hurt to include it on there, other than if you've got client concerns, but the IRS doesn't care. All right, so this, and I just got to say, if this was a football game, there would be a flag for this. This is the IRS, and this is supplemental reporting requirement. So here's what they say. The executor is required to supplement to report any omissions or errors on prior reports for anything that's not inconsequential. So the purpose is to make sure that the IRS has correct information on an initial basis. So you have to report any change. So if you found a new asset that you didn't report, you need to have a supplemental reporting. If you've had audit and you've adjusted values, a new report has to be filed. If you've got a disclaimer and you've got a different beneficiary, all of these things, you have to report again. So there's this ongoing obligation to have a supplement to your initial report. Now, if you've used that kitchen sink approach and given them information on all the assets, and then ultimately they only got part of them, you do not have to file a supplemental. So that's the benefit to doing that. You don't have to follow up and say, well, these are the ones you actually got. The IRS doesn't care about having that. And inconsequential issues, that's really, really limited. If you have an error in a last name, if you have an error in a Social Security number or an EIN, those are never considered inconsequential, and you actually need to file a supplemental return. So when you're in doubt, you should definitely report. All right, and again, if this was a football game, that would be the challenge flag on this one. Subsequent transfer rule is really, I think a lot of practitioners think the IRS has gone beyond their limits and regulations to require this. And lots of people spoke about this at the hearing. So here's how the rule works. If a beneficiary receives an asset from the estate that's reportable on Schedule A, and at any time transfers that asset to a related transferee, and that related transferee is determined under 2701, 2704, and includes a grantor trust, so if you transfer it to your grantor trust, in a way that results in that transferee taking your basis, then as transferor, you have to give a Schedule A to the transferee and to the IRS. So this is where I'm saying if you represent people who might inherit something, you need to pay attention to this. So And note here that it says a beneficiary who receives an asset that is reportable on a Schedule A. It's not that received a Schedule A. So let's say you have a beneficiary that 2 months ago inherited something and it should have been reported on a Schedule A and did not get reported on them. That doesn't relieve your beneficiary from having an obligation to then subsequently report the transfer to someone else. And this attaches to that asset as long as that basis keeps being connected to the prior owner in perpetuity. So this is something that could go on forever and ever. So it's the transfer that reports to the transferee and to the IRS, and also reports to the executor if the Schedule A hasn't come out yet because the estate hasn't been finalized. All right. Let's see, when are those due? The earlier of 30 days from the due date or when you file. I've never filed an estate tax return early. There might be some overachievers in the room who have. And if you have, just remember, you still just have 30 days from the time you file that return. And then for all of these other returns, it's basically 30 days from the determination that you found something else, or 30 days from the time you've transferred for a subsequent transfer. And interestingly, on the supplemental reporting, if you have a supplemental report, you can defer reporting until 30 days after the property is actually given to the person, which is the rule we want for everything to start with. We know they're capable of doing that rule, so we're hoping they'll change that. We're going to skip over penalties. Just suffice to say that you guys are all going to do everything right and never incur penalties. And also that the IRS is probably going to be fairly generous right now because they don't know what they're doing either. And if I had another red flag, I would throw it here. This is sort of like the NCAA death penalty, and being an SMU grad, I'm familiar with that rule. But this is the zero basis rule, which says if you have property that's discovered after the estate tax return is filed, the good news is if your statute of limitations is still open, then you can just supplement your return to report the property and you have your normal rules for basis. The bad news is if the statute of limitations has expired, that the basis of that property is zero. And there's no exceptions. The IRS feels very strongly about this. They think it's unfair. You didn't include it on your estate tax return and they can't go back and make you do it because the statute's expired. So they're going to give you a zero basis. Now remember, it's the executor that had to file it. Now it's the beneficiary that has the assets. So we'll see how that all sorts out. And then even worse, if an estate tax return has not been filed and you have after discovered or omitted property that makes your estate taxable and would generate taxes in that estate, everything in that estate has a zero basis. So that's a very draconian rule. None of us would intentionally omit assets, but it does happen from time to time. All right, in the outline, there's some do's and don'ts. I think probably the one thing to highlight here is that there's a very separate address for this return, so do not include it with your 706. And I don't really have time to go through the form. It's in the outline, and I point out some issues with the form. And just keep in mind, you're going to want a power of attorney filed with your 8971, but be sure to attach your power of attorney from your 706 with it so you don't accidentally revoke your prior power of attorney, following the rules for that. And we'll skip over to just a few little forms that you might want to file at the end. And I think the main one is discharging property subject to estate tax. If you've got an estate tax lien, you want to get that filed for your executor. So that's it of my presentation. I skipped over some things so we could fit it in. So if you guys have any questions, I'll be outside later to answer any questions. And I think maybe my outline, my email address is incorrect. It's missing an S in the middle somewhere. And so, but this is my correct email address if anybody needs to reach me. Thanks so much.
Thank you, Ms. Davis. Before the next break, we have one last drawing from Southwest Bank. Is it Michelle Dodd? Okay, congratulations. Go collect your prize. All right, so we have a 10-minute break, and we'll see you back here in a few minutes. Thank you.